we're going to discuss the actual rapid response investigation. The best way to answer the question is what documentation to provide and how to persuade OSHA that you are a safe company and that you protect your employees. This all started with a change to the record keeping and reporting regulation for you legal eagles or people who like to write down minute regulations. It's found in 29 Code of Federal Regulations, section 1904.39. The change in the rules requires an affirmative duty on employers to call and report anytime a worker is hospitalized, and hospitalization means an inpatient hospitalization. Amputations, no matter how minor, and the loss of an eye. The rule does define amputation and loss of an eye. I don't want to get too detailed on that today. For our purposes, anytime your employee is hospitalized, suffers an amputation, or loses an eye, you must report this to OSHA within 24 hours. The prior requirement of reporting a work-related death within 8 hours has not changed. This must be work-related. OSHA has no jurisdiction over injuries, even at the workplace. If it's not work-related, that's a whole other webinar on reporting. You're not required to report any injury or illness that is not work-related. This modification in the recording and reporting rule has resulted in a very large increase in reports to OSHA. This has had a significant impact on the available OSHA enforcement resources and activities. OSHA has developed a process for handling the large increase in reports created by this change in reporting requirements. OSHA has created a system for the intake of reports, the input of the reporting information into a computer database, and the sorting and triaging of this data to determine which reports will be inspected and which will result in a rapid response investigation letter. At the initial intake, the area office will get as much information as possible. Most of you will report this information by telephone. So when you first contact OSHA, you're just going to be basic, given company name, location, and time of the accident, the name of the employee, if there was more than one employee, how many, and whether you're calling for a hospitalization, an amputation, loss of an eye, or a fatality, and then the company contact person and his or her phone number. Now, at some point, either in that initial phone call or shortly thereafter, you're going to have a more extensive phone conversation with the intake person at OSHA. They're going to ask a little more detailed questions, and based on the information that you provide them, they'll make a decision on how to handle your report. Just want to give you an idea at this initial intake what the person at OSHA is going to ask. They're going to ask some questions about the injured employee, name how old the injured employee is, what parts of the body were affected, is there a hospitalization, are there other workers who were injured? If so, what are their names and ages? Then they ask about the workplace. What's the official name of the employer? What's the address where the injury occurred, if the address is different than the corporate address? What's a good telephone number to call and speak with the contact person? What type of industry are you in? Are you a staffing company? Are you in construction, manufacturing, transportation, nonprofit? They do ask a few questions regarding that. They're concerned. OSHA has a national emphasis program on staffing workers or temporary workers, so they're going to ask about that. They also will ask whether you have a union, and if so, who can they contact from the union? Do you have an employee representative on the safety committee? If so, they want the name and number of that person. Then they get into a little more nitty-gritty. They ask, when did this injury happen? What was the injured worker or the injured employee doing just before he or she got injured? What tools, equipment, or materials was he or she using? What directly caused the harm to the injured employee? A little bit later in our webinar, I'll talk about what they mean by direct cause. Is the hazard that directly caused the harm to the injured employee still in the workplace? You will hear me say over and over again, this is a primary concern of OSHA. Is the hazard still there? Are you on top of the situation? Could it potentially harm other people in the workplace? What steps have been taken to remove the hazard? And has something like this ever happened before? In fact, they even ask, has something like this almost happened before? That brings up whether or not you have a program that requires the reporting of near misses. So they're going to get as much information as they can. Obviously, you may not be able to answer all of these questions when you're calling within 24 hours. The initial data that is recorded at the onset of this interface between you and OSHA is reviewed by the area director. So what happens is, from a visual standpoint, just to let you know, this information is taken down by a computer program, it's sorted, and then it's reviewed by the area director or the area director's designee. And then a report, this report is sorted into either one of three categories. And we're going to talk a little bit about that. Category 1 requires an inspection. Category 2 may or may not require an inspection. They got to ask some questions, and it depends on your answer. Category 3, not going to require an inspection, but a rapid response investigation letter is sent, and that's what we're going to talk about. Now, in more detail, Category 1, this is going to result in an inspection. All fatalities, reports of 2 or more hospitalizations, injuries involving anyone under the age of 18. Do you have a history of multiple injuries or repeated citations? Are you in a severe violator enforcement program, or was this injury the result of some national or local emphasis program, such as forklifts? I know in our region, pallet manufacturing is a local emphasis program. And is there any imminent danger? That would mean, is there an explosion possible? Is there ongoing severe exposure to chemical hazards? If so, there's going to be an inspection. Now, if none of those criteria are there, then they move on to Category 2. Your report devolves to Category 2, and they start asking some more questions. Was a safety program failure the cause of the injury? Was a serious hazard involved, such as a major chemical spill? Once again, temporary workers. OSHA really is focused on temporary workers. You have a history of significant number of inspections. Was there a whistleblower complaint? And if you didn't know it, OSHA manages and is responsible for investigating whistleblower complaints for 24 different federal agencies. Was a referral from another government agency? What that means is that the police or fire department refer this. Are there any health issues, ongoing health issues? If you answered mostly yes to those questions, probably going to be an investigation or an inspection, on-site inspection. If not, then they're probably not going to come to your place and do an inspection. Instead, they're going to send out a rapid response investigation letter. This requires a written response. The letter is very interesting. I'm looking at a sample letter at this very moment. The letter starts out, this is a follow-up to the conversation we had on, and I'm going to pick a date, January 20th, 2016, which is yesterday, in reference to the above named employee that sustained an injury on, let's say, January 19th, 2016. I want to remind you that there are some important steps you should now be taking to ensure the safety of your workers. That's the velvet glove. They're very nice and friendly. We want to make sure that we're helping you do this investigation. And here comes the hammer. And avoid the need for an OSHA inspection. So what they're saying is, we want some information from you. If you don't give it to us, we're going to come out and inspect. And in fact, they specifically give you 5 working days, and they say in the letter, if we do not receive a response from you within 5 working days, your work site will be inspected immediately. The goal of the investigation, frankly, from our experience, is simply to find out that you're on top of the situation, that you're doing your investigation, and that OSHA doesn't have to worry about it. Along with the letter will be a non-mandatory investigative tool. We'll talk about that in a little bit. It's sort of like a flow chart with questions, and you are to input information into that flow chart. You are also to post a copy of this letter from the area director where employees can readily review it. Just like you receive citations in the mail, you have to post that. Then you need to return a signed certificate of posting. I'm going to say from a legal perspective, we question whether or not OSHA has jurisdiction to require you to post this letter, but it's not a hill that's worth dying on, so just do it. You have to be completed within 5 business days. This is a visual of what we just talked about. Category 1, you're going to get inspected. Category 2, the area director has discretion based on resource availability. That means, does she have enough compliance officers available to do an immediate inspection? And it depends on how many questions you answer yes. If so, you're going to be inspected. Otherwise, you go to Category 3, and you're dealing with the rapid response investigation. Now, I know that we have various levels of expertise, so if this is the time, I'm going to go through a basic education program for how to do an effective investigation. You need to investigate, analyze, and report, because that's what OSHA wants to see. They want to see that you've injured, not that you injured the employee, that you interviewed the injured employee. You interviewed witnesses. Take pictures of the accident area. Isolate the accident area and take pictures. I talk to compliance officers all the time, and they are always amazed that employers don't just take a picture of the area, because it's worth 1,000 words. Take some measurements and record the facts. As many of you understand, just report the facts. This is not time for value judgment, not time for the emotion. Just record the facts. Analyze the data. This is the beginning of a root cause analysis. What happened? Write it down step by step, flowchart fashion. Who, what, when, where, why. Let's go back to that slide for a second. Let's assume that you're doing a construction site and you have a company and they're working on a sewer area where the water drains down off the street before the sidewalk. You've roped off the area. You have spotters out there to control the traffic flow. You have barricades to prevent people from walking up and down the sidewalk. It just so happens that there's a wall that is a barricade as well between the sidewalk and a large apartment complex. And while the workers are there working on the sewer, they keep hearing voices saying 13, 13, 13, 13. During break, one of the workers decided to investigate. What in the world? What? I mean, it's a steady flow of 13, 13. He walks down the sidewalk a little further and finds a hole in the wall. He looks into the hole and gets stuck in the eye by a stick. Then he hears 14, 14, 14. So the moral of that story is wear personal protective equipment. That's the direct cause of that accident. We don't even need to ask why. But this is a typical question format that you ask, and continually ask why. Why did this happen? Why did he stick his eye in a hole? Why was he wandering down the sidewalk? Why don't you have rules that prevent wandering during job time? Then how do you write this down? Just write facts. Factual summary of the accident, because this is what some of the information you're going to provide to OSHA. State the direct cause, state the surface cause, state the root cause. I put these three different ways to analyze a situation in for educational purposes, and I'll define them in a second. Then, most importantly, and this is what OSHA is most concerned about, describe the proposed corrective measures so the accident doesn't happen again. I'll go back to what I said at the beginning. Words matter. Typical example for those of you with not a lot of experience in this area, it can be unsafe conditions or unsafe behavior. Unsafe conditions, examples would be an unguarded machine, defective or missing protective personal protective equipment, lack of ventilation, lack of housekeeping. That is oftentimes an easy citation for OSHA when they're walking through your workplace. Make it look clean. Otherwise, I mean, that's an easy citation for the compliance officer. And frankly, it's a cause of a lot of accidents. Unsafe behavior, working without fall protection, no excuse. This may sound kind of basic. Perform maintenance on machine without lockout, tagout. I have a workers' comp case at this very moment, very dramatic and severe injury that was caused because an individual was performing maintenance on a machine that was not locked out and tagged out. And OSHA came in there and hit the employer pretty hard on that. Okay, let's talk about three different ways to analyze an injury. Direct cause is defined as a harmful transfer of energy that produces injury or illness. Example, oil from a machine is leaking. Direct cause of the injury is the injured worker slipped and fell to the floor, fracturing the right kneecap and spraining the right wrist. That's sort of a shallow analysis of the situation. A little bit deeper, surface cause of the accident, defined as a specific unsafe condition or unsafe behavior that resulted in an accident. That could be described as the oil was on the floor because the machine had been leaking oil for at least 2 days and maintenance did not respond to the problem. So that's a little bit deeper analysis. A root cause analysis would result after going, why? The company didn't have a written maintenance program for the machine. So there was not a standard routine maintenance performed on the machine. The maintenance department decided they weren't going to respond because maybe they didn't even feel it was their responsibility. I don't know. But if you had a written maintenance program, that would be a very good start to preventing an injury like this. Visual, good way to look at this. The Dandelion Bloom is the direct cause. A little bit deeper on down where the stem is with leaves coming out, that's the surface cause of the injury. maybe an unguarded machine, or conditions or behavior would be horseplay, failure to report prior incidents that resulted in this accident. But you got to dig down under the ground. You got to go down further to find the root cause. One of my favorite in this slide is no disciplinary procedure. It's very easy to persuade OSHA that a company is serious about their safety program when they discipline their employees for failing to follow safety procedures. You're teaching your employees that safety matters and that you care about them. You don't want them to get hurt, and most importantly, you don't want other people to get hurt. All right, now let's get back. Let's get back to the substance now on how to respond to a rapid response investigation. You know, the little cartoon down there is very telling. They're sitting around the table, and the leader, the speaker, says, to address this mistake, we must use root cause analysis. And I'll begin by saying, it's not my fault. You must understand that a root cause analysis in an investigation of any accident is not to find fault. It's to find what caused the problem. So once the report is designated as Category 3, the area office must do a few things. The area office is required to identify the hazards, to provide abatement assistance, and then confirm that abatement of the hazard is completed. And they're required to do that by the Secretary of Labor. So that is why you're getting a letter in the mail that is requesting you put in writing that you've addressed this situation. So as I indicated, you have 5 working days to provide results of the investigation in writing, give specifics, the sample results, maybe receipts of a new machine or a new door or a new personal protective equipment that you bought to cure the hazard, photos, witness statements, interview statements, and then finally you have to provide written documentation of the abatement. So, typical questions that the rapid response investigation will ask is as follows. When did you stop beating your wife? That was a joke. I don't expect anybody to really answer that. But that's the way some of these questions are framed. They start out very innocuous again. You have to put in writing information about the injured employee, the amount of time they worked with the company, what kind of employee were they part-time, full-time, seasonal, temporary. Give a description of the injury, and then they begin to ask more detailed questions. And if I can digress here for a second, attached to the letter you receive will be something called, quote, non-mandatory investigative tool, close quote. It's a suggested format for you to follow in answering questions, providing the information to OSHA, and in performing your root cause analysis. We recommend that you respond to the requested information, but do so in a letter format as opposed to actually using this form. So you have to give a detailed description of the incident. What happened, what events led up to the injury, what happened during the incident, what happened after the incident, and you also need to provide information from the injured worker. Description of the incident from eyewitnesses, same thing, relevant events leading up to, during, and after the incident. You have to include the names of the witnesses, how to contact them because OSHA may want to contact them, and when you talked to them, the date and time of the interviews. Additionally, OSHA will want to know, are there any other employees who may have knowledge of this? If this is a result of a safety systems breakdown, they may want to just interview somebody on the safety committee. Now, this is the most important question that OSHA is going to ask. Identify the root causes. What caused or allowed this incident to happen? Now, as a lawyer, that's tricky. It's tricky. You want to address the questions that's asked by OSHA. You want to persuade them that you're a safe company. Answering questions like this can be difficult. If the safety procedures were not being followed, why were they not being followed? If a machine was faulty or a safety device failed, why did it fail? If you identify several factors, determine why these factors were not addressed before the incident. Sometimes you can't answer those questions. You do the best in your root cause analysis, why. Sometimes you simply can't answer all of the questions. We recommend, and we have over the last year, that the company provide as much information as possible in answering these questions, but do not volunteer or speculate on an answer. If you don't know the answer, don't put it in writing. If you don't know why safety procedures were not being followed, don't put it in writing. OSHA already has made the decision not to come out and do an on-site investigation. You simply have to comply, provide requested information to the best of your ability, and act like a Jedi Knight in Star Wars, just passing their hand over saying, you don't need to talk to us, you don't need to investigate us. We are fine. So don't volunteer information if you don't know it. You really need to establish corrective action. You really need to let OSHA know that you have done abatement, that the corrective actions taken to address the root cause findings have been done, and you need to document that. We recommend you use positive language, action-oriented language, that you found this and you did this and the employees are not in harm's way. Short, declarative sentences. You need to understand, and this is not to scare anyone, but this report, what you put in writing, can be used against you if OSHA decides subsequently to inspect and issue citations related to the incident. As I indicated, our experience thus far has been very positive. You probably have picked up at this point that your root cause analysis can be used as an admission of a violation. If the employer knew it was not in compliance before the incident, this could result in a serious or even a willful citation. So that's why I go back to answering the question. If you identify these factors, try to determine why these factors were not addressed before the incident. If you do not know the answer to that, don't speculate, don't volunteer. That is a red flag. Finally, this report may be discovered in a lawsuit if one occurs, such as an intentional tort lawsuit. So here I go again, words matter. Here's what we recommend. You paint a picture for OSHA. Remember, OSHA has the report of a serious injury. They've never been to your place of business. They have been placed with the responsibility by Congress to investigate and ensure a safe workplace. Spoon feed them. Let OSHA understand that you're on top of the situation, that you have a safe workplace. Provide as much information as necessary to persuade them that you're on top of the situation, that a thorough investigation was performed, the injured worker was interviewed, witnesses were interviewed, The management of the company is committed to safety in the workplace. That is a highlight for OSHA. They want to see that the employer, the supervisors, the managers, president of the company, everyone is committed to safety. Finally, if I hadn't said it 5 times already, I'm going to say it again. You need to tell OSHA that the hazard has been abated, if it has. If you can't get the hazard abated in a timely fashion, then tell OSHA that and ask for an extension. They'll give it to you. They're cooperative. I wanted to close by saying that OSHA is not your enemy. They may be your enemy in some sense, but it's like paying taxes. It's like the Internal Revenue Service. OSHA is there. They're a very active federal agency. They're going to intrude upon the workplace more and more, especially in the coming years. The fines for OSHA will increase by around 80% by the end of 2016. So it's going to be very costly if you are cited and that cited violation of a regulation is found to be valid. It's going to be costly. It is much cheaper if you define your own reality. If you establish a safety program, document training on the safety program, it will be much cheaper in the long run. Because if you do not do that, OSHA is going to define your reality. They will define it for you, and you may not like the way they define it. So maintain control of your workplace in the area of safety. Be compliant with the regulations, and I don't think you'll have any trouble with OSHA. In conclusion, over the last year, we have had very good experience with OSHA by simply answering their questions to the best of our ability in a timely fashion. Short, declarative, positive sentences. Let OSHA know you're on top of the situation. Document it. Document the hazard's been abated, and you will be fine. I think that ends the webinar. You have my contact information. Please feel free to email me or call us here at 419-244-6788.